Good morning and welcome to the Alabama Court of Criminal Appeals. I'll now take this opportunity to introduce you to my colleagues. To my right, Judge Samuel Welch, a native of Monroe County. To my left, Judge Elizabeth Kellum, a native of Tuscaloosa County. To my far right, Judge Lyles Burke, Marshall County. To my far left, Judge Michael Joyner, Shelby County. And I'm Mary Wyndham, originally from Baldwin County. And now I ask the Assistant Clerk, Jerry Robinson, to please call the case.
Case 11-1880, Jason Tulley versus City of Jacksonville. It's Calhoun Circuit Court, CC 11-1157. Arguing for the appellant is Joseph Baskier and J.D. Lloyd, and arguing for the appellee is Marilyn Hudson.
Good morning. Presiding Judge Wyndham, Your Honors, may it please the Court, my name is Joe Baskier, and I, along with J.D. Lloyd, do represent the appellant in this matter, Jason Tulley. With the Court's permission, we're going to bifurcate our arguments this morning. I'll be discussing and explaining why Mr. Tulley's conviction was not supported by sufficient evidence, and Mr. Lloyd will be discussing why Mr. Tulley's procedural due process rights were violated by this prosecution due to the statute in question being unconstitutionally vague. Before I start, I would note that we do respectfully request 5 minutes for rebuttal, Your Honors. I thought it would be prudent to begin with a short synopsis of the facts in this case because they are extremely important, I believe. The incident in question occurred on March 31st of 2011 in Jacksonville, Alabama, wherein Mr. Tulley entered into the First Educators Credit Union openly carrying a pistol and a holster on his hip. And that is uncontroverted, certainly. Because of the case law on this matter, we believe that the city of Jacksonville was only able to prove 2 of the elements in this crime, that being that Mr. Tulley possessed a pistol and that Mr. Tulley entered the First Educators Credit Union. They failed to prove the elements that are related to 13-1173, which we believe case law requires for a conviction under this statute if someone holds a valid concealed weapons permit. My argument is based on 2 primary concepts, Your Honors. The first would be that the city failed to establish and thus failed to prove their case that Mr. Tulley did not have a valid concealed weapons permit. The second argument will center on what does 13-1152 mean by premises not your own or not under your control. We should begin, I believe, by looking at those 2 statutes, 13-1152 and 13-1173, which for brevity's sake I will call 52 and 73, if that's okay with the Court. 52 is commonly referred to as possession of a pistol on a premises not your own. And of course 73 would be what we all commonly refer to as the concealed weapons permit statute. Case law is clear that there is a conflict between these 2 statutes. And I believe that this conflict has been resolved over time when looking at the case law primarily from this Court. You can sort of see the evolution of the law interpreting 52 as you look back through the decisions. There's actually a case from 1939, Stinson v. State, that appears to repeal 52. Actually, its predecessor in a previous code. I think that issue's been fixed by previous case law, so I believe we really began looking in 1962 and 1977 at Looney v. State and Morris v. State, both of which held that a permit is not required for someone to carry an unconcealed weapon while afoot. And I think that's important. Following those 2 decisions, we come to Braxton v. State, which was also decided by this Court in 1977, which says Section 161, which would be 52 today, makes no exception for carrying a licensed pistol, and thus, insofar as they conflict, 73 and 52 conflict, Section 175 would prevail, which is the predecessor to 73, it being the latter statute and a complete revision of the subject matter. Braxton v. State eventually led us to the seminal decision in this area, which would be CDJ v. State, decided by this court in 1995. CDJ begins with an in-depth discussion of Braxton v. State and appears to fully agree with its holding, and then focuses on the beginning of 52, which says, except as otherwise provided in this article. In interpreting this phrase, the court in CDJ essentially has recognized that, again, there's a conflict between the two statutes, and that for the prosecuting entity to convict an individual of violating 13A1152, they first must prove a violation of 73.
Where is the conflict as it applies in this case? Now, in CDJ, I think was a case where the individual had the weapon in the car, which would be in a concealed situation, right?
Correct.
Where is the conflict as it applies to this case?
Well, I don't know if I read CDJ to say that the conflict in that particular case is centered just on that case. I read the language to mean what it says.
But we have to find the conflict not from those cases, but from the substance of those two statutes, right?
Certainly. And Your Honor, if you follow the history of the case law, CDJ does involve guns that were in a vehicle and thus considered to be concealed. But there are other cases that don't. E.T. v. State, decided in 1996 by this court, was a juvenile carrying a pistol on the streets.
Again, that was not on the property of another. That was on the streets on public property.
That's correct, Your Honor. But if I may quote from that opinion briefly, they say, we reject the Attorney General's argument that 73 expands the scope of 52 to apply to public places. They do recognize that 73 is an exception of 52, and then they say, this exception is limited to those cases in which a person carries a licensed pistol on the property of others. So I think E.T. being the follow-up case to CDJ answers your question, Your Honor. The exception in 73, in light of that case, is limited to those cases where a person is carrying a licensed pistol on the property of others, which is exactly what happened in this case.
That was not the situation in E.T. He was on public property,
sure,
right?
Sure, certainly.
So that may just be dicta. Was it necessary to the holding in the case?
I think it was, Your Honor. I don't have the copy of the entire opinion in front of me, but I think it was. I think they made it a point. The court made it a point to say they're rejecting the Attorney General's argument. And
all these cases we're citing are cases out of this court, I believe.
Certainly all the recent cases, all of which, interestingly enough, involve juvenile defendants. And from 94 to 97, there's a series of decisions that sort of flesh out the interpretation of the statute. I think that's right. So I think that at the end of the day, it's acknowledged that 73 is the more important of the two statutes, the controlling statute, and like I said before in quoting Braxton, a complete revision on the subject matter. I do have limited time, Your Honor, so I do want to briefly move to my second argument, that dealing with the concept of what is a premises under 52. There's very little case law on this matter. We believe this is a matter of first impression for this court. We've had to look at other sources to help us define what premises is under 52. I think it's important to note when looking at the facts that Mr. Tulley was not on notice that there was any rule for customers entering the credit union that they could not be armed. The record reflects there was no sign posted on the front of the credit union. The record reflects that Mr. Tulley was not a member of that credit union. He was actually a member of a credit union from Colorado from whence he moved to Alabama and was just given reciprocal rights to do basic banking in the First Educators Credit Union. So he never received any personal notice from the credit union itself that firearms may or may not have been prohibited inside. And I think it's important to note when looking at the record that the arresting officer in this case, who was Officer James Clayton, wasn't even sure if a violation of the law had occurred when he was presented with this situation. He actually 2 days later went and conferred with the city magistrate to help figure out if a crime had been committed. I think case law makes it clear that one does not violate 52 when a person is carrying a pistol in public places. I go back to E.T. and their ruling. Isaiah v. State says that as well. We've looked at 13A1159, which is from the same title as 52, which defines a public place as any place to which the general public has access and a right to resort for business, entertainment, or other lawful purpose. I would interpret that to mean a public place is a place that's generally open to the public, which this credit union certainly was. We do have a discussion in our brief on 13A7-1, which describes what it means to unlawfully remain on a premises, and certainly that would not apply to this situation. That statute does include some mention of invitees, and I'll note that in the appellee's brief, they do admit that Mr. Tulley was an invitee to the credit union. Finally, we turn to, and we understand that this is not binding precedent for this court, but we do turn to the opinion of the Attorney General number 84-205, which was issued March 22nd of 1984. Attorney General opinion number 84-205. There are a number of questions that all involve 52 and 73 in this opinion, but directly regarding what we're dealing with. May a person carry an unlicensed and unconcealed pistol anywhere, either on his own property, public highways, public property, or on the land of another person? The Attorney General answered yes. There may be individual specific restrictions, such as airplanes, sports stadiums, and landowners or residents may exclude invitees who do not comply with their rules prohibiting firearms. That's really the crux of our argument when it comes to deciding what a premises means. It's our contention that we agree with the Attorney General in this situation. We believe that it's a business's right to bar or ban individuals from coming into their property while armed. But we also believe that individuals deserve to get notice that that is the policy of that particular location. I'd note, for whatever this is worth, as well, that there are no fewer than 7 bills currently pending in front of the legislature as we speak that are seeking to eliminate completely 13A1152 from the criminal code. In fact, Senate Bill 286 has passed the Senate, and they are holding a public hearing on that bill in the House as we speak. Lastly, in our opinion, were this court to agree with the city's interpretation of 52 and 73, it seems to me that the right to bear arms, based on this statute, would essentially limit you to your own home and your own vehicle if you had a concealed weapons permit. Testimony from Officer Clayton, again the arresting officer during trial, was chilling to me when he said, in his opinion, it's not legal for anyone to carry a pistol in public. And in fact later said it's his opinion that only law enforcement officials should be allowed to openly carry firearms in public places. I think that's a scary thought. And I think that destroys the intent of both the Alabama Constitution and the United States Constitution, which set out the right to bear arms. Again, looking at 52 and its potential impact on a citizen's right to bear arms, I see situations where were one to, for example, carry a firearm to a public firing range. Certainly you could get it from your house into your vehicle with a concealed weapons permit, but then when you get to the firing range, what tells you that you're allowed to go in there with your pistol? The business has let it be known that invitees are allowed to come in armed. Of course, that's why they're there. But under 52, based on the strict interpretation of the city, they might be violating the law. Private security guards that are carrying weapons may be violating the law. Stores that sell firearms may be violating the law. So I think there are a number of serious questions, Your Honors, and I'm going to stop for the moment and let Mr. Lloyd take up with the unconstitutional statute argument. Thank you.
Presiding Judge Wyndham, may it please the Court. My name is J.D. Lloyd. I will explain how Mr. Tulley's conviction violated his due process rights. Mr. Tulley has been convicted under an unconstitutionally vague statute. Section 13A 1152 is unconstitutionally vague because there is no punishment provision applicable to this offense anywhere in the Alabama Code or in our case law. I'd like to start off with just talking briefly about standards applicable to a vagueness challenge. As this Court's well aware, the vagueness doctrine is rooted in the 14th Amendment, the due process rights found within the 14th Amendment. There are two things essentially that are encompassed by a vagueness challenge. One, does the defendant or does the public have notice as to what sort of conduct is prohibited? And two, does the statute provide minimal guidelines for administration? Do police know what they're looking for? Do prosecutors know what elements have to be proved? Do judges know how to sentence? Now, we have searched the case law, and we cannot find a case in Alabama where there has been a criminal statute but no penalty provision. There's simply nothing that we have found in the case law. The United States Supreme Court has addressed these issues in federal cases and other state cases. And essentially, the United States Supreme Court has incorporated notice of punishment provisions into the vagueness doctrine. I'd like to direct this Court to U.S. v. Batchelder, 442 U.S. 1114. It's cited in our brief. But the Court said, so too, vague sentencing provisions may pose constitutional questions if they do not state with sufficient clarity the consequences of violating a given criminal statute. The Court goes on to say, so long as criminal provisions clearly define the conduct prohibited and the punishment authorized, the notice requirements of the Due Process Clause are satisfied. Clearly, this problem exists here in Mr. Tulley's case. I'd like to take a moment to look at the statute now as it's written, Section 13A 1152, and take a look at the history of how we got to the original statute to where we are today. In doing so, we're going to be able to see the holes that now exist and how they weren't there when the statute was originally passed. This statute that was originally passed that incorporated the offense of carrying a pistol about one's person on premises not his own is found in Act number 204 from the Alabama Acts of 1919. This act had 6 sections, the first of which was the first iteration of Alabama's concealed carry law, or prohibition, I should say. The second section was the substantive offense that would become eventually 13A 1152. And the third section was a penalty provision. And the penalty provision provided that any violation of any section of this statute would be punished, or one would be fined not less than $50 nor more than $500, and may also be imprisoned in the county jail or sentenced to hard labor for the county for not more than 6 months. So this was the original penalty provision applicable to the offense of carrying a pistol on premises not of one's own. The first time we see this in the case books, or I should say the code, is 1923. In the 1923 codification, we find the offense of carrying a pistol about one's person on premises not of his own at section 3487. Immediately preceding that offense in Section 3488 is the punishment provision for this offense. And essentially it was a restatement of the punishment provision that was found in the original act that was passed. Something changed. We don't know what exactly. But in the 1940 code, in the recodification, this punishment provision was no longer a part of the Alabama code. Now, the substantive offense of carrying a pistol about one's person on premises not your own was brought forward to Title 14, Section 163. Again, all these statutes are listed in our initial briefs, but one of the things that was interesting in looking at the statute is the title for each subsection basically has the old number of the old code from the predecessor statute. So in the case of carrying a pistol on premises not your own, the new offense was codified at Title 14, Section 163, but in parentheses next to it you could see 3487, a reference to the old offense in the old code. Nowhere in the 1940 code will you find a title that refers to Section 3488, the punishment provision originally applicable to the offense of carrying a pistol on premises not your own. It was lost. The legislature did away with it.
Did they repeal it?
Effectively, Your Honor. It's no longer in the code.
Well, now you say the fact that it's no longer in the code, does that necessarily mean it was repealed?
Your Honor, I believe it would be sort of a battle of semantics, but it's no longer in the code. Whether it was repealed, whether it was omitted, whether it was forgotten, it's no longer in the code. That's the operative fact here.
Now, the code's simply a codification of the statutes been passed by the state. They're for the convenience of the bench, the bar, and the public.
Mm-hmm.
Is it not?
It is, Your Honor, but we find no indication that the law is still valid. And as I'll get to eventually, this still goes back to the notice element, that there has to be a clear punishment applicable. If we couldn't find it, if Your Honors couldn't find it, how is someone untrained in the law supposed to find the punishment applicable to this proposed offense? Anyway, the 1975 code likewise does not have the original punishment provision. And as His Honors are very well aware, Section 13A 1152 likewise does not have this original punishment provision. It's no longer in the Alabama code. It's worth noting that in Title 13A, Chapter 11, Article 3, which is Sections 13A 1150 through Sections 13A 1184, it's the code sections dealing with handguns, firearms, and other weapons. The offense of carrying a pistol on premises not your own is the only substantive offense that does not have a punishment or a punishment provision attached to it. Every other substantive offense found in that section or in that range of statutes either has an explicit punishment, it has a designation such as felony, misdemeanor, violation, or it has some sort of catch-all provision at the end that says this is how it's supposed to be punished. I direct you to 13A 1184, for example, referring back to some of the offenses in the 70s. The next point is the code does not fill the void. There is nothing left in Title 13A that fills the void of how one is to punish someone for violating 13A 1152. 13A 53 states that all offenses are felonies, misdemeanors, or violations. And because there's no designation in this statute, we can't rely on these general principles. We can't turn to 13A 5.6 and see how a felony should be treated. We can't turn to 13A 5-7 to see how a misdemeanor or violation should be treated. Clearly, because there's no designation, we cannot fall back on those grounds. At trial, before the court rendered judgment, the argument again arose about the propriety of the sentence. It was the City of Jacksonville's argument that 13A 5-4C captured this statute. This was incorrect. The plain wording of 13A 5-4C states, every violation defined in this title is expressly designated as such. Everything that's a violation is called a violation. And then any offense defined outside this title without specification as to punishment, as to felony or misdemeanor, is a violation. Even though it read the plain language of the statute to the court, the city of Jacksonville wanted the circuit court to take the word outside and flip it to inside. Anything found inside of Title 13A should be treated as a violation. And ultimately, this was the sentence given to Mr. Tulley. Title 13A 5.4c does not authorize a sentencing court to take an undesignated crime within Title 13A and treat it as a violation. It would do so if something were found in Title 16, Title 20, wherever else in the code. But it explicitly says offenses found outside of Title 13A. This catch-all provision does not apply. Finally, I direct the court to the Attorney General agrees with this interpretation. In Attorney General's opinion from 1996-221, this is May 28, 1996, the Attorney General agreed that this provision does not work within Title 13A. This provision works outside of Title 13A to anything captured in the rest of the Alabama Code, not within the current criminal code. At this moment, I would like to reserve the remainder of our time for rebuttal. Thank you.
Thank you, Mr. Lloyd. Ms. Hudson?
I'm very honored to be here today. Thank you for allowing me, and I'd like to thank the City of Jacksonville for sending me here today. I'm Marilyn Hudson from Jacksonville, Alabama. My argument centers on legislative intent. 13A-1152 is a statute with which Mr. Tulley is charged with violating. 13A-1184 is the statute that has been discussed by my opposing counsel. 13A-54, paragraphs A and B state that the classification of each felony and misdemeanor designed in Title 13A are expressly designated in the chapter or article defining it. Obviously, in 13A-1152, it does not state the classification or penalty, and by error and mistake, the legislature clearly overlooked this in passing 13A-54. 13A-54 is designed as a catch-all. The actual language does say any offense defined outside Title 13A without classification or punishment should be treated as a violation. I would argue that the legislature, in stating that 13A-54, that all offenses contained in 13A are expressly designated, made an error. They actually intended for 13A-1184 to encompass things inside the title also. 13A-54 was meant to correct omissions both outside and inside of Title 13A, even though they used the word outside. 13A-1184 was passed in 1936, 1940, 47, 51, 67, and 75, and it gave classification and sentencing to 13A-1172, 73, 77, 78, 79, 80, 81, and 82. In my research, I found that 13A-1152 and 13A-1176, which is not part of our case today, were both left out of this statute simply by error and mistake. All the other statutes in 13A already had either classification or punishment and are clarified by either 13A-53, 54, 56, or 57. I would argue that the legislative intent of 13A-1184 was clearly to correct the absence of classification and punishment of statutes in Article 3, which is entitled Offenses Related to Firearms. including 13A 1150 through 85, and that 1152 was omitted simply by error and mistake, which was carried over several times through the years. As far as Mr. Tulley,
Before you leave that,
Yes,
let me make
sir.
sure I understand. You're arguing that we should disregard the plain language of the statute
yes, sir.
and apply the law as you think the legislature intended.
Yes, sir.
Do you have any case authority for that, giving this court that kind of authority over the legislature?
Jansen versus the state, 1962, told us that the legislature is all-powerful and their acts are presumed constitutional and valid, and that their statutes must be construed so as to sustain their validity unless clearly against all propriety, wisdom, and necessity.
So we're going to substitute our own judgment for that of the legislature on that issue?
The question I like answered.
No.
I agree that Judge Joyner's raised a very worthwhile point. Does the adoption of a code by the legislature that does not carry forth all the provisions of a previously enacted act, does that imply the repeal of part of that act? And I don't know if there's any case on that or not. I do know that a code is adopted by the legislature.
There are in the codes also specific provisions or list of sections that have been repealed. This section, the section from 1923, or that was originally passed in I guess it was 3488, is not in that list of specifically repealed sections.
So it really gets down to statutory interpretation. In that respect, I suppose we need to figure that out. But also, how do you get around this CDJ case?
The CDJ case was a juvenile. He carried an unconcealed pistol into a public place, and he also violated 13A 1173 because later he carried it in the car.
Right.
Yes, sir.
If I read CDJ right, they said the juvenile could not be convicted because the state did not negate his possession of a concealed carry permit.
The
In other words,
prosecutor.
because the state didn't prove he didn't have a permit, they didn't prove a violation of 13A 1152. Now, I just don't know how you get around that. I haven't seen a case changing that, and it looks like there's an earlier case also involving a juvenile, that maybe Edwards, I've forgotten, that deals with that same subject.
E.T. versus the state about a year later it was also a juvenile, if I'm correct. He was guilty of carrying a pistol on private property not his own. Therefore, the way I read it, 52 did not apply because he was on public property. And the state did not proceed to prove that the defendant was guilty of a violation of 73, not having a pistol license also. I'm sorry, Your Honor, did I?
Certainly. Thank you.
In my opinion, Mr. Tulley was not, if 52 is a valid statute, he was not in violation when he walked into the credit union, because in the transcript of the trial in front of Judge Thomason in Circuit Court in Calhoun County, the police officer could not state definitively that there was or was not a sign in the window instructing people not to bring weapons in, even though it is credit union policy not to have weapons on the premises. Mr. Tulley became in violation when he did not leave, when the security guard asked him to leave, and instead of leaving, he stood and engaged the security guard, arguing or discussing the case, whether he had a right to have the gun. And this argument or discussion lasted approximately 20 minutes. In the police report, it lasted from 1:30 until 1:50. And I feel that that's an unreasonable amount of time for him to have stayed engaging the security guard with a gun on his hip. The proper thing that he should have done that day was take the gun to the car immediately, come back, do his business in the credit union, and then, if he wanted to engage the security guard in a discussion, try to do so then.
So you're conceding that notice was required of Mr. Tulley.
And the security guard did give him notice.
So if he had immediately turned around and left the premises and put his weapon back in his car, he would have not violated the statute.
Yes. Focusing on something that's not just the law in our society, we are all concerned with the Bill of Rights, and we do have a right to carry weapons under certain circumstances as long as we follow the law in this country. But at the same time, we have to think about public policy and the safety of the citizens. And I would like to talk about something that happened in Anniston, Alabama in 1991. 3 men walked into Shoney's armed with shotguns. They hauled 20 people into the cooler and were threatening to kill them. One man, thank goodness, had a gun, a concealed weapon with a license. Looking at it from a purely common sense view, the law side, if Mr. Terry at Shoney's that day had had a gun on his hip in plain sight, it is very possible that one of those 3 men would have shot him immediately when they saw that gun, knowing him to be a threat. Thank God he had it concealed, and he had the opportunity to save not only himself but 20 other people. One must use common sense when carrying weapons, and because of all the problems that we're having in this country with shootings and things like that, I think that when you start carrying a gun just down the street, it scares people. I think that your decision here today will make a lot of difference in society, and you should think about all the consequences. Would y'all like to ask me any more questions? I think I'm done. Thank you.
Thank you, Ms. Hudson. Mr. Basquier.
Thank you, Your Honor. Briefly, I find it quite shocking that the city has just admitted that Mr. Tulley didn't violate 52 when he walked into the credit union. And then she says that he violated it when he remained in this discussion with Officer Clayton inside the credit union. I have the record in front of me, Your Honors, and the time frame that was just quoted by opposing counsel of a discussion lasting from 1:30 to 1:50 is nowhere to be found in the record. There's no indication that the discussion between Mr. Tulley and the officer lasted that long. In fact, it appears to be a very short conversation wherein Officer Clayton asked Mr. Tulley to leave or get the gun out of the credit union. Mr. Tulley explained to him it was his constitutional right to have the weapon in plain view in the credit union. Officer told him to get it out, and Mr. Tulley went back to his vehicle, placed the weapon back in the vehicle, came back into the credit union, and completed his banking. There's no indication that this was a lengthy argument in the record whatsoever. So we would certainly dispute that argument. I'm going to let Mr. Lloyd address 2 other issues. Thank you.
Mr. Lloyd.
One of the important Supreme Court decisions I think that this court needs to take careful judicial notice of is U.S. v. Evans. This is at 333 U.S. 483. In talking about the issue of legislative intent and what the legislature intended to do and what the legislature perhaps did not intend to do, we would first like to say we rest on the plain wording of the statute and ask this court to apply the words as they're written, as this court knows it is to do. But in Evans, Mr. Evans was charged under the Immigration Act of 1917 for harboring or concealing illegal immigrants. And the Act of 1917 basically criminalized two things, or the attempt to do two things. On one hand, it was the bringing into the United States, or attempt to bring into the United States, illegal immigrants. On the other hand was the concealing of illegal immigrants, or the attempt to conceal illegal immigrants inside the United States. In the statute, the punishment provision was likewise included within this substantive statute. And basically the statute said, if you are convicted under this statute, you shall be deemed guilty of a misdemeanor, and upon conviction thereof shall be punished by a fine of not exceeding $2,000 and by imprisonment for a term not exceeding 5 years for each and every alien landed or brought in or attempted to be landed or brought in. The statute did not talk about the harboring or attempt to harbor of an illegal alien. And essentially the United States government argued it was clear what Congress wanted to do. They just left out a little bit of language. They left out the harboring or attempt to harbor. They clearly wanted to give them this same fine and this same penalty in terms of a jail sentence. The court rejected that analysis. That is a purely legislative function for the legislature to decide what sort of punishment is applicable. And they would not go as far as to say, this is what the legislature probably intended, and we're going to go ahead and say that this is the punishment that would have applied to your crime. The court did not allow that to stand. The court explained, but as strong as the presumption of validity may be, there are limits beyond which we cannot go in finding what Congress has not put into so many words, or in making certain what it has left undefined or too vague for reasonable assurance of its meaning. There is no way for Mr. Tulley to know what punishment he faced for possibly walking into the bank that day with his pistol openly carried on his hip. There's nothing in the Alabama Code. Perhaps if we dive into the books, there's something way down there about that. There is no notice. And this brings me full circle to the vagueness. There is no clear punishment provision. And I'd like to quote from, I apologize if I butcher this pronunciation, Giacco v. Pennsylvania, 382 U.S. 399. Pennsylvania had a statute that let the jury just fix cost for someone convicted of a crime. The court rejected and struck down this statute and explained, certainly one of the basic purposes of the Due Process Clause has always been to protect a person against having the government impose burdens upon him, except in accordance with the valid laws of the land. Implicit in this constitutional safeguard is the premise that the law must be one that carries an understandable meaning with legal standards that courts must enforce. Thank you, Your Honors.
Thank you. First of all, I was remiss in not thanking counsel and others for accommodating the court and being prepared to move up the arguments 15 minutes. The court appreciates that accommodation. We also appreciate your fine efforts this morning, your arguments this morning. We appreciate it very much, and we'll certainly take it into consideration for our deliberations. Thank you, and now we're adjourned.